Hi, this is Mike Cohen from Gray Plant Mooty, a law firm in Minneapolis, Minnesota. And I just wanted to mention what I believe are the three main concerns that a Danish business should consider when they're looking at the United States as a market for their products and services. And this is particularly in the life sciences area. So one thing you might want to make sure when you're talking to your professional advisors that they understand that there is an interplay between the FDA regulations and the U.S. patent procurement process, and so that your patent attorneys really have an understanding of what the business objectives are, and also that the FDA counsel and compliance people that you use don't put anything in the FDA reports that's going to be detrimental to your patent strategy. So the key point there is make sure that the business people communicate and are effective in how they use both their patent counsel and their FDA advisors so that everything fits together. The next point I would like to make is if you're a Danish company and you may be a target for an American company who's interested in licensing your technology for distribution in the United States, or maybe even acquiring you, you're in a much better position to get your own house in order relative to what intellectual property rights you might have. You know, do you have copyright protection? Do you have the appropriate confidentiality agreements in place with your employees so that trade secrets are protected? You know, do you have your trademark portfolio properly protected, as well as obviously your patents? And it's as simple as just making sure that the information is readily available so that when the attorneys for the other party start doing their due diligence, you don't have any surprises, they're not surprised, and don't start asking you questions that you might not have the answers for. And I think that it'd be well worth doing that when you're not under the stress of a company that's looking at putting a value on your business. The last point I would make is that there are different forms of intellectual property, and they all have different purposes, and depending on your unique business, product, and service, some may or may not be appropriate, and you might want to have a strategy in how and when you spend your money for pursuing those different levels of protection. And when you're using license agreements, whether it's a distribution agreement, an exclusive or non-exclusive license agreement with a partner, make sure that you really focus first on the business purpose and objective, and then from there you can have your lawyers craft the appropriate agreements, whether it's a particular field of use that you're going to restrict the licensee in, or how the royalty payments might be structured, or any number of other issues that might seem like legal contract terms, but they really should start with a business perspective, and then the lawyers can, do their job, and that's to put together the appropriate agreement that reflects your business interests. Thank you.